Good afternoon, everyone. Thank you for joining us for our annual Final Disposition Law Seminar. I just want to throw in a few housekeeping items. One is on the right-hand side of your screen. There's a place where you can type questions in. Please type any questions in that you have during the webinar, and we will answer them for you. Also, we ask that you give us 7 to 10 business days to upload the credit from this webinar to your portal. At this time, I will turn things over to our Executive Director, Mike.
Thanks, Kelly. Good afternoon, everybody. Thank you for joining us this afternoon. Before we jump into the topic for today, I had recently been asked by a couple of folks who had regularly joined us for our COVID updates each week. I don't know how many folks on the call today listened in on those, but you may recall that I would start with, or try to start with, a joke every now and then. And folks said, how come you stopped doing that now that, when you do your CEs, you don't do that? And I was thinking, well, with COVID and the dire situation everyone was facing, I thought a little levity would be good. But then I thought, well, maybe it wouldn't be so bad to just try to start a CE with a joke as well. So worst case scenario is it's a really bad joke, which I'm sure this one is. But in the interest of start things off with a little humor, here's my joke for you today. A funeral service was being held for a woman who had just passed away. As the pallbearers carried the casket out, they accidentally bumped into a wall. They then heard a faint moan come from inside the casket. So they opened the casket and found that the woman was still alive. She went on to live 10 more years and then died, so they held another funeral for her. While the pallbearers were carrying her out, her husband yelled, "Watch out for that wall." Okay, like I told you, it's pretty bad, but there's my attempt. So for all those folks who have been asking me for a joke, there it is, and you probably regret having asked me for one, but too late now. All right, so today's topic is final disposition, and really what that means is we are going to walk through the public health law, specifically section 4201. So, prior to this law being passed, funeral directors have dealt with the question of who controls a person's final disposition. Increasingly, funeral directors found themselves in the middle of disagreement or outright disputes amongst family members as to the method and/or the procedure of a loved one's final disposition. In addition, the landscape, as you well aware, has been altered by the complexities and realities of today's society, which includes more non-traditional family structures. This factor presents emerging legal and practical challenges for funeral directors who are also looked to by the deceased survivors to make the decision as to which of them has the legal authority to control their loved one's final disposition. However, again, as you all know, each situation is unique, and funeral directors are not always made aware of all the facts in a particular case. It's also extremely important to note that prior to this law, New York State did not provide funeral directors with any specific guidance as to how to handle these situations or any explicit legal protections when doing so. Too often, funeral directors are put in the uncomfortable position of taking sides with one party over another, and by extension, seemingly endorsing a type of disposition that could ultimately be found to contravene the wishes of either the deceased or the loved one possessing legal control. Of course, the irreversible finality of cremation raises the stakes even further. So needless to say, such a role goes well beyond a funeral director simply acting in a less risky, albeit important position as a mediator or arbiter. New York's final disposition law provides funeral directors with heightened levels of clarity in dealing with family disputes, as well as significant liability protections that had been non-existent in the funeral laws of our state prior to this law being passed. So with that backdrop, let's jump into the presentation. So I mentioned that prior to this law, there was really no protection. So the law itself was passed and became effective in 2006. Since that time, there have been amendments made to the statute twice, once in 2007 and a second time in 2012, and I'll note both of those amendments throughout the presentation. The purpose of this law is really fourfold. The first, or one of them, is to create the priority list or next of kin hierarchy, which I'm sure all of you are very familiar with. The second was to be able to appoint a legal representative, which we obviously all call the agent, to control disposition. The third was to create those liability protections that didn't exist. And that is for both you as funeral directors and the agents or the people in charge of final disposition. And then lastly, there were provisions included to help with that dispute resolution that takes place. So all in all, really it was and is a roadmap for funeral service when we are dealing with final disposition. So a little disclaimer before I jump into the sections of the law. Since we're reviewing the law and specifically a statute, words are very important. So I included a lot more on the slides than I normally would, because I think you need to see the words of the statute. Also, as I walk through this, I am actually going to do this section by section in the order that it's set forth in the statute. So I bring that up because I think this might be a little bit different order or way than it's been presented in the past. So just so you know, we're going to walk through the statute section by section in the order that it exists in the law. Not surprisingly, and as in most laws and statutes take place or are drafted, the definition section starts the section of law. So there are a few definitions under this section of law. Ironically, though, the law does really not contain very many defined terms for this one. They define disposition, domestic partner, and person. Those are the three defined terms. So we'll take a look at each of them and see what it specifically says. So first, disposition. Disposition in the law is defined as the care, disposal, transportation, burial, cremation, or embalming of the body. So that is technically what disposition means when we are talking about it under this section of law. A domestic partner is a person who is to another person one of certain things, and these are the things that are listed. So you can be a domestic partner through being formally a party to a domestic partnership under state or federal law. You can do so and create a domestic partnership through registration, being registered as a domestic partner of the person with an employer or any federal, state, or local municipality. You can be formally named as a beneficiary or covered person under the other person's employment benefits or health benefits. Or this is kind of a catch-all. It is a domestic partnership can be created or defined through dependent or mutually interdependent. You are dependent or mutually interdependent on the other person for support based on totality of the circumstances. So there's not like the domestic partnership. If you're formally under a agreement, you're registered in the state. Obviously, if you're named in health insurance or employment benefits, there's a document that shows what the relationship is. Barring one of those, now you're looking at the situation itself and trying to determine if there is one. And that, again, is dependent on this totality of the circumstances, meaning no one of these or a certain number of these is defining or determinative, but taken together, when you look at all the different things that would show interdependence or dependence on the other person, they would show that there's a domestic partnership. And those things include common ownership of property or joint leasing of property, living in the same household. So you're in a common household and you're sharing income and sharing expenses. If you have children in common, if you had intended to be married or become domestic partners and you had their signs of that intent, and also the length of the personal relationship. So those would be factors that would be looked at. With regard to the first two, the party to a formal relationship or agreement or registration, just so you know, under New York law, under state law, if you were to create a formal partnership in an agreement, the partners will actually get a certificate showing that they are domestic partners once that is approved by the municipality. You can also be registered, and that's available both under New York State and New York City statute. Okay, so they define what a domestic partner is, but the law is also very clear about certain circumstances where you cannot be a domestic partner. And really what this is the anti-incest rule. It's to prevent folks who are related from claiming domestic partnerships or just being domestic partners. So you can't be a domestic partner of somebody else if you're related to them by blood or marriage, if you're under the age of 18, if you're an adopted child of the other person, If you are related by blood in a manner that would bar marriage in New York to a person who is the lawful spouse of the other person. So those are all the basic, like I said, anti-incest. So it's those situations where someone, despite all the other totality of the circumstances, would not be able to claim domestic partnership. And then the last phrase that is defined is the word person. And under this section of the law, a person is a natural person who is 18 years of age or older. So again, that's really that age of adulthood by the law. So they want to make sure that somebody who is deemed a person when dealing with the final disposition is at least 18 years old. All right, so the next section of the law happens to be the one most often relied upon, and it's the area where we get the most compliance calls, and this is the priority list or the hierarchy that is set forth in the law. So this section of the law specifically states that the following persons, again, these are the people 18 years or older, in descending order have the right to control disposition. So this numbering system that you see here is actually the ranking system. So you go, the people with the lowest number are the people who have the highest ranking, and they are the ones who would control first. So again, here's the list of people who would have the right to control disposition. The first is the person designated in writing, and that's either through an agent form or a will. One or the other instruments is the written instrument or the writing that they're referring to. If there's not a person named, then you would go to the person's spouse if they have one. If there's not a spouse, then you would go down to a domestic partner if there's one, and any child 18 years or older. And you notice it says any child. So any one, even if there are multiple, has the right to control either parent or any sibling 18 years old or older. So again, if there are both parents are living, either one can control. If there are multiple children or siblings 18 years or older, any one of them can control. Obviously, a question we get a lot about, or a lot of questions we get are about these particular, especially the children and siblings ones, where you have disagreement amongst people of the same category. Dropping down further, then you'd get down to a legally appointed guardian, any person entitled to share in the decedent's estate, which we'll go into a little bit more, a duly appointed fiduciary of the estate, a close friend or relative who's reasonably familiar with the decedent's wishes, which we'll talk about as well, and a public administrator or anyone willing to act on behalf of the decedent. So that's the list that is in the law currently. You'll notice a couple of asterisks here. So with regard to that, let's look into that a little bit more. So when it says any person entitled to share in the decedent's estate, you actually need to look at it in terms of this following order. So here's a sub-priority list for that specific section. So if you were at that level and you were dealing with a person who falls into this category, now you have to look and see what relationship they have to the decedent in terms of who has the priority. So first would be grandchildren, then great-grandchildren, then nieces and nephews, grandnieces and grandnephews, then grandparents or aunts and uncles, first cousins, great-grandchildren of grandparents, and second cousins. So again, this is a second sub-list for that one particular group of people who might have priority or control of disposition. The other footnote is as it relates to the close friend or relative who's familiar with the decedent's wishes, or the public administrator, or anyone willing to act on behalf of the decedent. So a close friend or relative who's reasonably familiar with the decedent's wishes, or the public administrator, or anyone willing, has to complete the at-need written statement of person having right to control disposition form. So you could fall into that category and be the person, but you need to complete this form in order to be the person who ultimately would be allowed to control disposition. This is very different from the appointment of agent form, which we will be going over shortly. So just wanted to point out the distinction there. All right, continuing on. So that was paragraph A of section 2 of the law. Now we're looking at the next couple of paragraphs, B and C. And what B and C really talk about is looking at some what-if scenarios that the law was trying to address. So what if the person who has the right to control is alive, but they're unavailable, they're unwilling, or they're not competent? So you go down and maybe you get to the spouse, and the spouse is one of those things. Let's say they're unwilling to control the right or unwilling to control disposition. So what do you do in that situation? Well, then you go to the next person in line. So you either go to another person with equal priority. I mentioned it could be any child or any sibling, so you go to another one. Or you go down the list to the next person on the list. So that's the what if the person is unavailable, unwilling, or not competent. The second part is the duties of the agent or person in control. So is the person who's in control, do they have any certain specific responsibilities in terms of how they have to conduct their business? So yes, there are. The law specifically states that the person who's in control or the agent has to carry out the decedent's wishes to the extent lawful and practical. So what does that mean? That means you have to consider the financial capacity of the decedent's estate and other resources available. So if you had a funeral that you had prearranged and maybe not pre-funded that was $15,000 and the estate only doesn't have the money to cover it and there's no other funds available, then it would not be reasonable for that person to have to carry out those wishes to that extent, as an example of that. It also has to be consistent with the decedent's moral and individual beliefs. Now, interestingly, there was a case from 2012 that deals with, this was a case from 2017, a New York court case that actually talks a little bit about this particular circumstance. So here's the example and here's the case summary for you. So the facts of the case were a woman died, leaving no specific written instructions as to how she desired to be buried. She had been divorced twice from her children's father, and so yes, she was divorced twice from the same person, and had purchased a cemetery plot with him decades ago. Her surviving adult children were the legal next of kin, and by law the first in line to control her final disposition. Since her estrangement from her now deceased former husband, she, along with her sister, purchased a cemetery plot in her family's home country of Israel. In the years immediately before her death, she continually expressed her desire to be buried in Israel to her sister and her home health aides. She did not put her exact wishes in writing. She did provide her adult children with the information related to her newly purchased plot in Israel. Now, the children wanted to bury her in a plot she purchased with her ex-husband that was located in New York City. The woman's sister then petitioned the court to override the children's decision to have their mother interred in New York City, arguing that they were knowingly going against what their mother had been telling others. So they held an evidentiary hearing where they heard from the children, sister, and health aides, and then the court ruled that she could be buried in Israel. The reasoning was that the adult children's testimony focused primarily on what they thought their mother would say or do, rather than what she actually said. And as such, they did not represent the personal and direct knowledge about their mother's wishes. Yet the home health aides testified that they had actual conversations with the decedent where she clearly expressed her desire to be buried in Israel. So really, when you look at this court case reiterates the underlying key messages of the section of law. So again, first and foremost, the law provides that list of people reasonably responsible to carry out the decedent's wishes. The survivors have the responsibility to strive to fulfill their loved one's wishes. The decedent's wishes are paramount to the survivor's preferences. Anyone with knowledge or evidence that the legal next of kin is acting explicitly against the decedent's wishes may petition the court to halt the disposition. A person's competence to act relates to their ability and willingness to carry out the decedent's wishes to the extent they are known. So competence may not just mean mental capacity. It could be your ability and willingness to do what the decedent wanted. When someone's unwilling or unable to carry out the wishes of the decedent, the court must proceed to the next applicable person on the hierarchy list in Section 4201. And lastly, the person in control of disposition must faithfully carry out the directions of the decedent in a way that's in line with the moral and individual beliefs and wishes of the decedent. So the important takeaway, and something we always recommend, is that when there is evidence of a family dispute, or if the funeral director has knowledge or reason to believe that the legal next of kin is not acting according to the decedent's written directions or expressed wishes, the funeral director should take pause and direct the family to go get a court order to direct them all in how to proceed. So another important piece of this section of law, in addition to talking about following through with what you know the decedent's wishes are to the extent possible, is that the person who is responsible for controlling disposition is not liable or responsible for paying the expenses. So being the agent does not make you in charge of the expenses. Being the agent only deals with the responsibilities of controlling disposition. That's another question we get quite often. So we're still in Section 2 of the law, but now we're jumping into a couple of other sub-paragraphs, the next two, D and E, to talk a little bit about some additional responsibilities, or some direction. So can a funeral director be the person with the right to control disposition? So the answer is yes. A funeral director or your employee can be a person with the right to control. However, if you are that person, you cannot receive any compensation or receive any financial benefit just disposing of the decedent's remains. So if you take on that role, you can no longer be the funeral director who's getting paid for the responsibility. You can still perform the services, but you cannot get paid for doing so. Another section of this paragraph deals with orders of protection. So who could not be in charge, even if you're on the list? Someone is prohibited from serving as a person in control if either they're subject to an order of protection at the time of death, or they've been charged with the decedent's homicide. The only time that can be waived or modified is by a court order where the court finds that doing so is in the interest of justice. Ironically, there is another court case that dealt with this in 2020. This section of law is the one that came into place in 2012. I mentioned there were amendments twice. One was 2012. This was the amendment known as the Anti-Domestic Violence Law Amendment. So this created that protection there. So that court case from just last year, February of last year, again, a New York court case, the facts of that case were as follows. There was a husband who went to state Supreme Court seeking an order to control the disposition of the ashes of his wife. The wife had an order of protection against her husband at the time. So the husband sued, and he sued his daughter and the funeral home. And then what wound up happening, so according to the court documents, the daughter stated that she had scattered all of her mom's ashes in Lake George, and that she then threw away the container. So then she didn't have the ashes anymore. So what the court said was that even though this husband had or the woman had an order of protection against her husband, the court's decision was that the husband was the person who has the right to control disposition of remains of his spouse. And further, they declared and directed that the temporary order of protection issued by the family court is not an order of protection within the meaning of Section 4201 of the Public Health Law, as it would disqualify him from controlling the disposition of the remains of his spouse, and that even if it is, a waiver of the disqualification is appropriate in the interests of judgment. So the order of the court was that in the event of the ashes of the decedent or the box or container in which the ashes were delivered to the daughter and the funeral home should basically come back into her possession, the daughter has to immediately deliver the same to her dad or the woman's husband. So two takeaways from this. You'll notice at the end of the order, the judge used the phrase interest of justice as a reason for his decision, which goes right back to the section of law. The only thing that's very problematic from my standpoint, and for those who don't know, I am an attorney as well, it's problematic to me that the judge interpreted the final disposition law in a way that is clearly contrary to the plain language of the statute when he opined that the order of protection issued wasn't one that would disqualify her husband, because the section before the one saying it could be waived clearly states that if there's an order of protection at the time of death, that is a reason that you cannot be someone who can control disposition. So it's a very perplexing case there. I don't necessarily agree with the judge's decision, but this just goes to show again why it's so important whenever there's a question and potential legal dispute that you take pause and make sure that things are handled by the court and you get direction from the court. All right. So now we're going to slide over to the next section of law, which is the actual appointment of agent. So the law itself actually has the form that you would use specified in the law itself. So if you go and you look up the law, you're going to actually see this language in the law. So I'm not going to read the whole thing. I'm sure you're all very familiar with this form. But I just want to make sure that you're aware of a couple of important points that this form talks about. So, and I've highlighted those. So you see at the top, obviously, the person's going to fill out their name, and that they're talking about this is the person who is ultimately naming somebody else to be their agent. They are specifically stating in here, the disposition of my remains shall be controlled by. So now you're naming the person that you want to be the agent. We'll talk about the fact that naming the person is not enough, but it is obviously a very important step. And then there's special directions. So what is that? Why is that important? Why did I bring that up? This talks about that other section I just mentioned, and the court case from 2017 I talked about. This goes to that where the person in control has to carry out the decedent's wishes to the best of their ability. So to avoid a situation like the one where you had a person who's not sure or thinks that somebody wants to be married one place and somebody's arguing they want to be buried somewhere else, if the person who is appointing the agent at the time wants to be very specific about what they want done with their remains, they can list it there, and then that gives clear direction to the agent as to what they should be doing. There was also a section in the law here that says that if you have entered into a pre-funded pre-need agreement to indicate if you have or haven't, and the name of the funeral firm in which you've entered the agreement, and that's just to help the agent know where to go. Now, another question that we had gotten in the past was, hey, does the firm, if you're named in this, does that now have to be the firm that handles the case in order for the agent designation form to remain valid? And the answer to that is no. 453, the pre-need section of law of the general business law, that does not control this. So you can put all this information in, say yes, name the firm, but then when it comes time, if the firm has been changed or if a different firm is used, it doesn't invalidate this form. You'll see at the bottom there is more than just the agent's name. You're going to repeat the name but add other contact information to the form. And then if you want to name successors, you have the ability to name an successor. So that would be something that would happen. At the bottom, you'll see when it says duration, it says, this appointment becomes effective upon my death. Why do I bring that up? I bring that up because this is very different than a power of attorney or even a healthcare proxy. So a power of attorney is valid only while the person is living. Once the person dies, the power of attorney doesn't work. So when someone comes to you and says, oh, I'm a power of attorney, I have control of disposition, that doesn't mean anything in terms of controlling disposition. The agent form is the only form that does. The same is true for the healthcare proxy, only while you're alive, except for one provision in the healthcare proxy that does survive death, and that's if the decedent has chosen to make any type of anatomical donations, and those would continue through past into death. The last part of the form allows the agent to indicate that if they have, or clarify that if they have done a prior appointment of an agent form, that they are revoking anything prior. So the most recently dated is the one that's going to apply. So I could appoint my wife and then all of a sudden things aren't going well. Maybe we're still legally married and I want my child to do it. So I'm going to sign a new form that's going to give my child the right to control my disposition. The individual has to sign the form. It has to be witnessed by two people. One can be a funeral director, or you can have a funeral director witness. And then, as I mentioned earlier, it's very important, obviously, to name the person. But the person being named does not automatically become the agent unless that person accepts the appointment. And they have to do so by signing the form at the end. And that ensures that the agent can't be appointed without both their knowledge and their consent. All right, so moving off of the form. So what if you don't have an agent form? Is there anything else you can rely on? So as I mentioned up front, it says a writing. You can appoint an agent in a writing. So the other document you can use is a will. So you can rely on a will if the will specifically states in there that you're designating a specific person to dispose of one's remains and or direct how to dispose of the remains. So it shouldn't just be, it's not just the executor in a will. It's somebody specifically stating in the will that they're appointing someone to take care of their remains and directing how they want that done. Now, if you did a will, and then later you do an appointment of agent form, the agent form is going to control over the will. So again, it's whichever is the most recent written instrument, that's the one that's going to control. Again, you can revoke it at any time as the person who appoints the agent. You don't need the agent's permission to revoke it. The person appointing can revoke it unilaterally. And if the decedent's spouse or domestic partner is designated, you can revoke it, but it also automatically will become null and void as an appointment if you are legally separated from your spouse or divorced, or if there's a termination of the domestic partnership. So those are the ones that by operation of law will stop that stuff. So when you're revoking, you can either do it through executing a subsequent written instrument, which we see in the form, it'll say that. That's by signing a new agent form, you're revoking the first one. Or you can do it by any other subsequent act by the decedent, evidencing a specific intent to revoke the prior written instrument. Again, any other subsequent act by the decedent evidencing an intent to revoke the prior written instrument. That's kind of broadly stated. So again, another reason why anytime you're dealing with a dispute or uncertainty, you should stop and wait for a court order if there's anything that's not clear. All right, so looking at liability protections, which are one of the four pieces of the law that we talked about. Again, a person, and which by they say a person in the law, they mean the individual who's stating that they have the right to control and disposition. So that person who's acting reasonably and in good faith is protected from liability by representing themselves as the person in control, by disposing of the person's remains if done in accordance with the law, again, through the person's wishes, or just even by identifying the deceased person. So this protects the agent or the person who's coming and doing this from liability for these three things. I mentioned it also protects the funeral director, and the funeral director or the firm who's acting, again, reasonably and in good faith, is protected also from liability for doing any of the following: for carrying out the written directions of the decedent set forth in the appointment of agent form or will, or for carrying out the directions from the person representing themselves as the person in control. But the caveat there is if you're going to rely on that person, you have to get a written statement from that person stating that they are either the designated agent in the will or written instrument, that they have no knowledge that the decedent executed a will or a written instrument, meaning the agent form, and that they also are the person having rights to control under the priority list. So the state association has created the at-need written statement of agent and at-need written statement of person form. That form is not available through the Department of Health. The Department of Health, if you talk to Tom Fuller or anyone in the Bureau, they will tell you to rely on our form. They have said that in several CE sessions that you may have attended. So that form is available to you to rely upon. Looking at dispute resolution, which again was one of the pieces of, or the last piece of the law that we said was major portions of it. So a dispute regarding who has control of disposition where the persons involved cannot resolve it themselves shall be resolved by the court. That's in the statute itself. So again, I've been telling you there's reasons to pause. Well, here's the best one of them all. Don't take it from me, take it from the statute. It specifically says that if there's a dispute, the court has to resolve it. Secondly, a funeral director cannot be held liable for refusing to provide services if a dispute exists until you've received the court order or some written form signed by all the parties to the dispute establishing who has control. So again, there's your liability protection. So people can start claiming they're going to sue you and do all this other stuff because they're getting upset. but they're not going to win because the law clearly tells you to stop and wait till you get a court order. Or you can have another document. So if you're going to use a non-court issued form, make sure it has a hold harmless clause in it. So, for example, if you have, say, 3 adult children, so again, remember the law and the priority list says any one of them can control. Well, let's say we have 3 and they can't agree on cremation or burial. But now they later come back to you and say, okay, we all agree we want to bury mom. So now you have to get that in writing with a hold harmless clause written into it saying that, they all agree that they want mom buried and they are going to hold the funeral director and funeral home harmless from relying on this written document to go forward. Make sure all of them sign it, and then you are completely protected under the law. So as you can see, there are a lot of good pieces to this law. It's one of the strongest, if not the strongest in the country. Others have modeled their laws after ours. Believe it or not, there are states that don't have any type of priority list, and it's the Wild West. Some of them are actually in the West, so not surprisingly. And there's, but as good as it is, nothing's perfect, right? So I just wanted to give you all a heads up that we are working towards potential amendments potential amendments to the law that we are going to try to look to improve it. I'll give you just an overview of what some of those are going to look like. So we have had issues where the public administrator, if they're in charge, they're very reluctant to choose cremation because of liability purposes. So we would clarify that they have the right to choose cremation without liability. We would also like to include a time frame on the person in control disposition to act, something reasonable, but so that this does not drag on, because we've heard from many of our members who are kind of caught in limbo as people just continue to not make a decision, and they're the only ones who can. We could allow any person who's willing to act, including the funeral director with custody of the body after a certain amount of time, to be able to act under the section of law. We'd also, under the section that deals with any child, any sibling, to have majority control in those situations, so you don't have to get everybody to agree. So in that scenario that I just explained, if you had 3 children who were disputing, if you get 2 out of the 3 and they're willing to sign off, then you could go forward and be protected as the funeral director. We'd also want to clarify that a funeral home would have the ability to embalm or refrigerate and shelter the body and charge for those services when there's a disagreement and while you're awaiting the decision of the court, because again, sometimes that takes some time. And then lastly, we would like to, this is not specific to this, but it's related. We'd like to permit an individual to be able to authorize his or her own cremation. As you know, the customer's designation of intentions and cremation authorization form is not a form that the individual themselves can select cremation from. It's the people who are in charge of disposition. So we would like the person, the decedent themselves, to have the ability to authorize his or her own cremation. So those are some changes that we're looking to work towards as we move ahead. All right, so last section is your pop quiz. So not sure how many of you are still awake. If you're not, wake up, wake up, wake up. We have a couple questions for you guys. Okay, can a funeral director be appointed the agent? Hopefully you are listening. Yes, but if you are, you cannot be compensated or receive a financial benefit. Question 2, true or false? The person paying the funeral bill automatically has the right to control disposition. False. And as I mentioned, not only is that false, but the person who does have rights to control is not responsible for paying the bill. So the person who pays the bill just pays the bill. That's all they're doing. Is it possible for a person to be appointed an agent without knowing it? Nope. As I mentioned, you have to accept the appointment in writing. So at the end of that form, that agent will be signing on to the form saying that they understand what they're being asked to do and they are accepting that appointment. Does a person need an attorney or a notary public when filling out the agent designation form? You do not need either of those two, but you'll recall that there are two witnesses that need to sign the form. And as I mentioned, a funeral director can be a witness. The funeral director just can't be an agent unless, as we said, you are not going to be compensated. Is the funeral director responsible for or required to obtain documentation for proof of a domestic partnership? So the legal answer to this is no. The law does not specifically state that a funeral director has to have proof of this. Because what's going to happen is the individual will sign the at-need form attesting that they have the right to control and why. So they're going to, when they sign that, they're basically saying, well, I'm claiming I'm the domestic partner. I'm signing the form knowing the list, and this is what I'm saying. So you can under the law rely on that form so long as it's reasonable to do so. So here's the thing, though. You may want to see some documents so that you are proving you're acting reasonably, right? So especially if there's a dispute. So if there's a dispute and it's not, you don't, obviously if you have something like an agreement or a registration or they're signed on as beneficiaries of that policy that I mentioned, the insurance or health insurance, then that's pretty clear that you have that evidence and you're covered under the law. What if it's that totality of the circumstances? Well, then finding out if the person who's claiming to be a domestic partner, have you had children? How long have you lived together? Do you share all the expenses? Do you own a house together? Some of those things will help ensure that it feels reasonable. Now, again, if you're kind of in that gray area, as soon as you start asking, the question I always get is, am I now taking on more liability because I'm asking the questions and I have to make sure that all these things are on the up and up? No. Reasonable for you as a funeral director is, hey, I'm being told that there's this list of things that show that there's a domestic partnership. Can you prove or can you tell me that if any of these things exist? So if they're telling you that they do, that's plenty. If they happen to have a utility bill that shows that they're together or a deed to the house or something along those lines, even better. But you're not required to get those things. Again, the biggest problem is when there's a dispute. And if you have a dispute, the best thing to do is pause and wait for a court order. But in the absence of that, if you feel relatively comfortable, you can rely on the at-need form, asking a couple of questions to make sure that you've taken a couple extra steps. I don't think hurts you. I think it actually helps you. Our next question is, are there any situations when the designated agent or legal next of kin may not have a legal right to control disposition? And the answer to that is yes. There are two places. One is the order of protection, despite what that court case says, or if you're charged with the homicide of the decedent. Now, again, you don't have to be found guilty. If you're just charged with the homicide, then you can't control disposition. We've actually had one case, our call come in where that was the case, where the person had been charged but not found guilty yet. And the question was, can they control? And it was pretty easy to answer because the law specifically states that once you're charged, you no longer have the right to control. Scenarios, I'm sorry, I don't know why this is giving you the answer so fast, but pretend you're not seeing the bottom. The scenario is 3 children meet with you to arrange for their father's funeral. 2 children want dad to be cremated. The third does not. What do you do? Actually, I'm sorry. This is not the answer. These are the options. You go with majority rules, dad will be cremated. You refuse to cremate because one child objects. You tell the children you can't help them and you direct them to another funeral home. Or you wait and you direct the children to obtain a court order to determine who has control. So you definitely want to refuse to cremate if one child objects. Clearly that is irreversible, so you don't want to do that. And the best thing we would recommend is wait and direct the children to obtain a court order to determine who has control. We've had some funeral directors who've decided to follow number 3 and just tell the children you can't help them and direct them to another funeral home if it gets really bad. But our best advice is to wait and direct the children to get a court order. The other option is not getting a court order. If they all come back and all 3 agree that now they want to either bury dad or they want to cremate dad. If they're going to cremate him, make sure you get all three to sign saying that they agree to do that and that they hold the funeral home harmless from proceeding. Question 8. Can the funeral director act as, can the funeral director, it should be act as one of the two witnesses required for the agent designation form? All right, so yes, the funeral director can act as one of the two witnesses required for the form. Of the following individuals, which one has the highest ranking on the next of kin final disposition list? Executor, public administrator, grandchildren, close friend or relative who knows the decedent's wishes. This one's kind of hard because these are all pretty far down the list. The answer to this one is grandchildren. They are the highest amongst those on this list, and when it relates to controlling disposition. And we have one more question for you. True or false? A designated agent can refuse to serve at the time of need. Kind of a trick question, but the answer is true. So we mentioned, right, the agent is unwilling, unavailable, or not competent. So if you're refusing, you're actually specifically deciding not to. So that's not unavailable, and that's not that you're not competent. It's basically you're saying you're unwilling and refusing to do it. So if that does happen, then you go to the next person in control based on the priority list. So that covers just about everything in that section of law. Hopefully that was helpful for you. Thank you for listening, and I'm happy to answer any questions that I can in the time we have remaining. So Kelly, I'll turn it back over to you.
Yeah, we do have a few questions. And this kind of goes back to the question you just mentioned. A man and woman have lived together for 30 years. She dies. Who is her legal next of kin, the male partner or her adult children?
So living together for 30 years, I mean, if you go back to the slide in the beginning that talks about the domestic partnership, and when you're looking at the totality of the circumstances, living together, so 30 years is clearly the length of the personal relationship. That's pretty long. If they shared income, like living together, they shared the household or common householding, I think you check that box. If they were sharing expenses by living together or the income they made, if they happened to own the property, then the house they were living in together, all those things would clearly point to domestic partnership, and that person would have the highest priority on the list at that point above children or siblings. So that I would say that in this circumstance, based on that, if just the common householding, length of the relationship, if there's shared income and expenses and or common ownership, then I would say that person who was living with the decedent for those 30 years is a domestic partner and would have control.
Okay, so the next one is situational. If there are 3 children, can the waive the right of disposition form be signed by 2 of the children to leave the third one in charge?
Yeah, so again, the law is only saying any person can be in charge. If there are 3 all on the same playing field or same priority level, and 2 of the 3 are saying we don't want control, then that last one would clearly have control, and that would protect you because you have the other 2 saying in writing that they don't want to. So yes, if you got those 2 to say they were disclaiming it, then the third would definitely have control, assuming that they're willing to do it.
And this goes back to the beginning of your presentation. When you mention the word will in number 1, does the executor or executrix have the
Yep.
Yeah, have the authority to sign for cremation?
No. So the executor of a will is not a person who is an agent in control. The will itself as a document can be the writing used to appoint an agent. So unless in the will, the executor or executrix it specifically states that I am appointing that person to control my disposition, and this is what I want done, then that is not, just by being the executor or executrix, that does not mean you have rights to control. You would not go to that person. You'd have to look at the priority list under Section 2 of 4201.
If the person being appointed is not available at the time the form is signed, can they sign later?
I do not know of any requirement that the form be signed simultaneously with the person designating or appointing the agent. However, clearly, later has to be before the person passes away. You know, that's kind of obvious. Like if the form is not signed at the time of at need, then that's not going to be valid. I do know that there has been a time when we got a call with a dispute because it was literally 10, 15 years later when the person signed the form. And our recommendation was just to make sure a court would consider that still valid because how much time had passed. But at its face, it wouldn't be invalid as long as there was still a signature and it was dated, and nothing subsequent revoked it. So in terms of just simultaneously having to sign, there's nothing in the law that says that. As long as the agent accepts their appointment and signs and dates it before at need, hopefully in a reasonable amount of time afterwards, you should be fine, or you will be fine. No if about it.
Where would the guardian of an underage child fall on the hierarchy?
So interesting, we had something similar to that asked of us when we had like a foster parent. I'm wondering if someone they were fostering who passed away, they could control disposition. And so the guardian's a little different because the guardian is actually one of the people listed on this priority list. So a legally appointed guardian is actually number 7. They're right after any sibling. So it goes agent, spouse, domestic partner, child, parent, sibling, guardian. So as long as it's a legally appointed guardian and you have the paperwork to show it, the guardian would then be number 7 on the list.
Can a power of attorney sign the agent form on behalf of the person appointing an agent?
So that's an interesting circumstance, right? So you have, so it really depends on, so here's what, generally speaking, a power of attorney, if it's a general power of attorney, they have the ability to sign documents on behalf of an individual. However, there's a caveat about certain documents that you couldn't sign. So like a power of attorney couldn't sign somebody's will on their behalf. This one falls from the last conversation we had with the Bureau. This one would fall outside the scope of that as well. A power of attorney, unless there was specifically a court saying that the power of attorney had the right to sign that form on behalf of the person, that would be most likely something that the individual would have to sign. Now, if the person, because here's the reasoning, right? I'm of sound mind and body. I'm appointing this person. I want to control my disposition. If the power of attorney is signing it, then how do you know that the person was actually capable of appointing that person at the time? And I think that's where the conversation needs to go, and that's something that only a court could resolve if there's a question.
What is the legal mode of transportation to send the skeletal bones of a human to another state? Shipping via air, FedEx, UPS, U.S. mail, or just via a vehicle?
I am not familiar with any limitations in terms of which mode of transportation must be used. We can look that up, or if anybody on the attending happens to know if there is or isn't and would like to type that in, we can get an answer now, but I am not aware of any limitations in terms of that, but that doesn't mean there aren't any. I just don't know the answer off the top of my head.
Okay, and going back, and I don't know if this was a follow-up question or the same question, but can a power of attorney sign naming themselves the agent?
No. No. I don't think that again, if that's, to me, that doesn't make any sense. I would, again, though, caution and say that would need to be adjudicated with a court. I don't think a power of attorney's powers would allow you to appoint yourself to do something like that. And I remember having a conversation. I can't remember the specific details, but I remember a conversation about that probably 2 years ago, where I'm pretty sure that the answer was no, they couldn't. But to be 100% sure, you might need to have a court if there's a fight, just give a direction on that. But the power of attorney language does not allow a power of attorney to appoint themselves to other agent positions.
What if a mother and a father are accused of murder of their child? Do they have the right to control disposition?
So, interesting use of the words, right? So words are important in these situations. Accused is different than charged. So if both parents were formally charged with the murder of their child, then neither is able to control disposition. If it's an accusation and no formal charges have been brought against them yet, then they either of them are still in control.
What is the time frame, or is there a time frame, for being considered a domestic partner?
So there isn't a specific time frame. That's that totality of the circumstances. The longer you live together or are together in a relationship with another person, the more likely you are going to be able to prove domestic partnership. If you want to have an agreement, a formal agreement, or register, then the state application will ask those questions. I'm not sure if there's something specific. I do believe that there's probably a time frame that they would look towards, but from the totality of the circumstances situation, there's nothing specific. It's really just looking at everything. So the longer, the more likely that a domestic partnership is in place. And obviously, if there isn't something in the statute that says if to get into a formal agreement or to register, one of the criteria is you have been in a relationship for X period of time, then that's as it relates to the formal agreement. And if they have a certificate showing that they're in a formal agreement, or a registration certificate that they're registered as partners, then that takes care of that anyway on your behalf. So the only time it would come up for you would be in that there's no formal document and you're trying to figure it out. And in that case, again, there's not a specific time frame that is a minimum.
And this is a comment going back to the guardian question. The question the funeral director was asking was about a guardian for a minor child, not a deceased.
So can a guardian of a minor child control disposition for the child? I guess it sounds like then what's being asked is, if there's a child under 18, but you have a guardian who's appointed for that child, can they step into the shoes of and be in that priority list as someone 18 years or older? If that's the question, the answer is no. The legal appointed guardian that I was referring to would be a legal appointed guardian over the deceased, or of the deceased.
Okay. If the agent is unavailable or unwilling to control the disposition, does it go back to the hierarchy list?
Yes. If the agent is unwilling or unavailable or not competent to serve at the time of that need, then you go down the list. Now, obviously, the agent is number one on the list, so now you're going down. So unless there's a will naming somebody else, now you're going down to spouse, then domestic partner, and so forth down the list.
And then on the agent form, there are successors. So if the agent is unwilling or unavailable, does it first go to the successors and then the hierarchy list?
Yes. If there's a successor named, then the successor so if you go back to that form, it'll say, if my agent dies, resigns, or is unable to act, I hereby appoint the following person person to serve as my agent to control disposition of my reins as authorized by this document, and you'll have those individuals. Now, clearly, if you have a successor agent that you want to appoint, you should have the successor sign on as well at the bottom of the form, indicating that they would be willing to accept the appointment. Because again, the whole point of this is that they know that they're going to be, and they're willing to accept it. So you would want to make sure that any successor has also signed on accepting their appointment so that you can rely on that. If there's not a signature and there's somebody named, then the intent of the decedent was to have that person serve as a successor. You could go to that person and have them sign an at-need saying that they were named, they'll be, oh, yep, I'm an agent. I was named as a successor. And then at that point, they're willing to accept it, and you'd still be covered.
Okay, so the other one is a clarification. Just because a person is the executor of the will, they do not have ultimate control, correct?
Correct.
In regards to indigent, unclaimed, or abandoned deceased, does a public administrator have the right to sign for cremation?
So they do, but as I mentioned, one of the changes that we're looking to do is to make it very clear that they don't have liability for doing so, because they have been reluctant in many cases to do so. But there is nothing that says the public administrator, if you get down to them on the list, that their ability to control disposition is limited to burial and not cremation. It doesn't say that. So they have the right to choose either. It's just that because of the circumstances that you're dealing with, the irreversibility of cremation, many have been reluctant to do so, which is why we wanted to change the law to clarify it. But the law does not limit them or prohibit them from choosing cremation.
When you refer a family to court to get a court order, which court do you send them to, and do they need an attorney?
So generally, we would say you don't necessarily need an attorney. It's usually there's an estate involved, so sometimes you already have attorneys involved. But it would be surrogate's court, or you could go to Supreme Court. But usually, like a surrogate or family's court, is they understand the need to act expediently and quickly, and you would usually have more luck in getting that resolved there than you would other places. So surrogate's court is the place that I would recommend going first.
Okay. So this goes back to a legal guardian signing on the form on behalf of someone. Is it the same as a power of attorney? So we're back to the legal guardian.
So agent form. So like this is the question I think is a legal guardian allowed to sign on behalf of the person appointing an agent for the person who's not signing themselves? I go back again to the situation where the form is saying that, it says at the very beginning, I, being of sound mind, willfully and voluntarily make known my desire that upon my death, the disposition of my remains shall be controlled by. So again, the sound mind, willfully and voluntarily, I think because of what we're talking about, if the individual themselves are not able to sign the form and make the appointment, then I would question whether it would be upheld, especially in a situation where you're dealing with a family dispute. Clearly, if there's no other disputes, no one else willing to step up, it's different. But assuming that you are dealing with a situation where someone else on the list would be, I'm going to caution, because it's not clear to me if that person would have the authority and under what circumstances, if it would be fact specific. I would recommend pausing and looking to make sure that that document is deemed valid by a court in order to move forward.
Going back to the agent form, the witness, whose signature are they witnessing? Both the agent and...
Nope, they are just witnessing if you look at where the witnessing is done, the witnessing is done on the form above where the acceptance of the agent is. So what they're witnessing is they're witnessing the individual making the making the appointment. So I didn't read this part, but this kind of helps clarify it. So the person appointing the agent signs directly under their signature is the statement, "I declare that the person who executed this document is personally known to me and appears to be of sound mind and acting of his or her free will. He or she signed or asked this document in my presence, witness 1, witness 2. Ironically, there is a section in there that says he or she signed, and then in parentheses, or asked another to sign for him or her. So again, there's that question mark about could the guardian or the power of attorney or somebody else. The law does not specifically talk about who can sign on behalf of somebody else. So that's why I would take pause, but especially because it does say that the person appears to be of sound mind and acting of his or her own free will. So if there's any question of that and the person's not signing because of that, that's why I would pause. But the witnesses are only witnessing the person who's making the appointment, and they're actually not only just witnessing the signature, but they're witnessing the fact that they believe the person is able to make this appointment because they are of sound mind and acting on free will. So that's what they're witnessing. They're not witnessing the agent accept it. They're just witnessing the person making the appointment.
And must there be 2 witnesses? If there's only one, is it void?
The law states that there has to be 2 witnesses. So I would say it's not valid unless there are 2 witnesses.
Okay.
I'm just
and the last one.
Hold on 1 second, Kelly. I'm
Sure.
just pulling the statute up just to make sure that if it says it in there. I don't remember ever reading anything that said that it has to be signed. But when the law says it says and properly witnessed. So properly witnessed to me means both witnesses are on the form, because otherwise it wouldn't say. It would just have one name. So yes, I'm going to say that is both that need to have signed in order for it to be valid and fully executed.
Okay, and the last one is just a comment, and this goes back to earlier, what we were discussing earlier. On the at-need right to control disposition form, the following statement is at the bottom. I also have no knowledge that the decedent executed a will containing directions for the disposition of his/her remains, contrary to those being arranged or designated an agent by executing a written instrument pursuant to Section 4201 of the Public Health Law.
Was there a question or just a comment?
Nope, that was just a comment.
Okay, yep.
And I think that went back to something you spoke about earlier on.
Yeah, so I mean, again, the at-need form is basically reiterating what the agent designation form said, and that the person who's at the time saying they control is saying they're not aware of anything else that would prevent them from acting in that capacity. They're kind of swearing to that to make it more protection for the funeral director, and the agent again the person at need is going to be protected as long as they were acting reasonably, and clearly if they're lying and they knew of something, they're not acting reasonably.
Okay, that is all the questions. So thank you all very much for attending. Thank you so much, Mike, for presenting.
Sure.
And like I had originally stated, give us about 7 to 10 business days to get your credit put on the portal. Oh, I have one more question if you have a second, Mike.
Sure, yep.
Okay. If a person is married, but they haven't been living together, and the deceased has been living with someone for the last 10 years, who is in charge of the disposition?
If they are still legally married, the spouse who is no longer really in the picture other than through operation of law is in charge. So the spouse, until you're divorced or legally separated, is still the spouse under the eyes of the law, and that person has control.
Okay, and that would be it.
Great. Thank you all. Have a great rest of your day.